first things that you must pay attention to when you separate from your partner, whether it's through a divorce or just you were living together or you had children together, is child and spousal support. Spousal support can also be known by the name of alimony pendente lite. The initial proceedings on these issues can set the stage for the remainder of the case, whether it be cooperative or contentious. To calculate both child and or spousal support is based on net income. That is income that is determined after you subtract out the taxes, federal, state, local, any health care costs, Medicare contributions, union dues, mandatory payments for something that your employer requires. Any and all sources of income are used for determining spousal support, but for child support, your full-time job is used and any mandatory overtime is considered. Voluntary overtime or a second job is not considered for child support. When you are summoned to a support hearing, you must bring 6 months of pay stubs, your most recent income tax return for yourself and if you have a business. Any child care costs, any unreimbursed medical bills for dental, vision, and also psychological or psychiatric services. As of this time, any cosmetic surgery bills or something that is not medically related will not be covered unless the parties agree otherwise. If you're seeking support for someone who is on SSI, they cannot count their income. But if that person is receiving Social Security disability benefits, that will be a source that will be considered for the support of either the child or the spouse, or both. If the child is receiving some sort of Social Security benefit on account of one of the parents, that benefit is added to the income of the receiving parent. Then the benefit is deducted off the child support obligation if the parent receiving the benefit and the child living with that person are the same. So there is consideration given if the child is getting some sort of derivative benefit from Social Security on account of one of the parents. Child care and other expenses are allocated between the parties without considering that derivative benefit. And child care and other activities that may be sharing in expenses between the parties is based upon the incomes of the parties. So maybe one party makes 85% of the income of the two parties, or maybe it's 60-40. It just depends. And that's how we base the payment by either party as to that percentage that that party has out of the two parents. I know that's a little bit confusing, but it's easy to understand once the numbers are run on your case. If you own a business, the support calculation looks at several things that they will add back into your income, such as business depreciation, deductions, and capital outlays. So if you have a business and you think, wow, I show no income, that may not be correct. And in those cases, again, you may want to have an attorney. Certainly, you may also want to have your business accountant take a look at what your return looks like so that you have a better idea of what may be used to calculate the child support. Personal injury awards and workman's compensation awards are considered as income and may be allocated over a year. It may be divided up, and then that particular amount per month is used to calculate a support amount. If the requesting party is not working and they have a child or children who are under school age, or they have a physician verification form completed that says that they cannot work, then they will not have an income imputed. If they have a child who is school age or older and they have no medical issues, then an income will be imputed. If they have specific training, such as a nurse or a teacher or in some other field, they may be imputed at that higher income. It just depends if they have worked in that field recently, or is their training quite old? If they have no specific training, maybe they didn't work during the marriage, then they will at least be imputed a full-time minimum wage income. The hearing officer can deviate approximately 10% from the guideline amounts that the state set forth in determining what the child support amount should be. Maybe the spouse that has to pay the support has some sort of medical issues or some other extraordinary expenses that may cause the hearing officer to seek that deviation. The support order can be modified every 6 months based on changes in circumstances. Someone lost their job, they got laid off, or they had a serious accident. But if something happens within that 6 months of time, in order to get a new support hearing, you would have to file a waiver, and that is done through the court system. The judge has to sign off on that. Also, if you don't like the support order, you can appeal it and go before another hearing officer. Now, that support will still stay in effect. The order that was entered will stay in effect until you have that hearing and possibly another order is entered. At that hearing, you can bring witnesses, you can bring experts to testify about your medical condition, or an accountant, or whoever you need to prove your case. On January 1st, 2019, the law changed regarding the taxability and deduction of payments. So if you're getting alimony or APL, you can no longer count that as a deduction. It is considered income to the person receiving it, and it is not deductible to the person paying it, where it used to be the opposite. Also, only the primary custodial parent can claim the child tax credit. I have mentioned that APL, or alimony pendente lite, is a remedy to seek support for a spouse when a divorce is filed. The spousal support is only when a divorce has not been filed, but they're essentially the same and they're calculated the same. Sometimes the divorce must be filed to get support because there is a defense to the spousal support payment, such as if the spouse left the marital home, the other spouse can say they were abandoned. But sometimes the spouse must leave because of domestic violence. Also, if there is domestic violence by one of the spouses who is seeking the support, they could be barred from seeking that support if they were the cause and found guilty of domestic violence. Even if you're living with a new partner, alimony in the interim can be awarded. The reasoning is the monetary support is to equalize the parties through the divorce process. Now, that could be a bar to you getting alimony, but until that is determined and the divorce is finalized, you can cohabitate. Finally, parties, as of many years ago, are not obligated to pay for children seeking to go on to college. If the parties agree to do this voluntarily, that can be written into an agreement, but there is no requirement that one party is obligated to provide that support for the other. And this is a constitutional issue that was struck down by the Supreme Court many years ago, saying that the parents were not obligated to provide that support. Also, there are special circumstances for children who may have disabilities, and the courts can order support well beyond their age of majority, which in this case is 18 or whenever they graduate high school, whichever is later. And sometimes children with special needs may not graduate until much later, such as age 21 or 22. So as you can see, support, it can be complicated, but it's so necessary to move on with the process of your separation from your partner or divorce from your spouse. Highly recommend seeking legal counsel to get some of these questions answered. It can only help to increase your benefit that you may receive through this process. Give me a call.